Most people believe that if the police say, "We got a call," it means something real, something verified, something you're already halfway guilty of. And that belief, more than anything else, is what gets them into trouble. Because the truth is, "We got a call" doesn't mean what you think it means. And more importantly, it doesn't give the officer nearly as much power as your instincts are about to hand over. I've sat through hundreds of hours of body cam footage, watched people talk themselves from a simple encounter into a criminal charge, read transcripts where one sentence, just one, became the turning point in a case. And if there's one pattern that repeats itself over and over again, it's this moment right here. The officer walks up, calm voice, neutral face, maybe even polite, and says, "Hey, we got a call about you," or "We got a call about this vehicle," or "Someone reported something suspicious." And right there, something shifts inside the average person. You can see it happen. Their posture tightens, their voice changes, their brain starts racing, trying to figure out what the call was about, trying to clear things up before it gets worse. They start explaining, they start filling in blanks, they start talking. That is the moment the entire encounter turns. Because what most people don't understand is that "we got a call" is not evidence. It's not proof. It's not even necessarily reliable. It's a starting point for the officer, nothing more than a reason to come talk to you. In legal terms, depending on the situation, it might contribute to reasonable suspicion, or it might not. Sometimes it's vague, sometimes it's anonymous, sometimes it's flat out wrong, and sometimes it's used exactly the way you just felt it, like a psychological lever. Here's where this gets complicated. The law doesn't operate on your feelings in that moment. It doesn't care that you want to clear things up. It doesn't care that you think cooperating will make this go away faster. What matters is what you say, how you say it, and whether you unintentionally give the officer something they didn't have before they walked up to you. And this is the trap. Because the officer doesn't need the call to be perfect. They don't need it to be airtight. They just need you to talk. Let me tell you how this plays out in real life. An officer gets a dispatch. Caller reports a suspicious person sitting in a parked car. That's it. No crime. No description of illegal activity, just suspicious. The officer drives over, sees you sitting there, maybe on your phone, maybe waiting for someone. Completely legal. Completely normal. But now the officer approaches and says, "Hey, we got a call about this vehicle. What are you doing here?" And right there, you have a choice you probably don't realize you're making. Most people respond instantly. "Oh, I'm just waiting for my friend." Or, "I just got off work." Or worse, they start adding details, trying to sound normal, trying to sound harmless. And in doing that, they open doors the officer didn't have access to before. Because now the officer can compare your answers, test your consistency, look for nervousness, look for contradictions, extend the conversation. And conversations are where cases are built. Now this is the part most people misunderstand. You are not required to solve the officer's uncertainty. You are not required to explain yourself just because someone made a call. The Constitution doesn't evaporate because a stranger picked up a phone. But none of that matters if you don't assert it calmly and clearly in the moment when your instincts are telling you to do the exact opposite. So there's a phrase, one phrase, that changes the entire dynamic of that encounter. And it's not aggressive, it's not disrespectful, it's not confrontational, but it is firm. And it draws a line the law actually recognizes. "I don't answer questions. Am I being detained or am I free to go?" That's it. That's the anchor. That's the moment you stop the drift. And I want you to notice something about that phrase because this is where people get it wrong. It doesn't accuse the officer of anything. It doesn't escalate. It doesn't challenge their authority. It simply does two things at once. It asserts your right to remain silent, and it forces clarity about the nature of the encounter. Because legally, every interaction with police falls into one of a few categories, whether you realize it or not. Either you're free to leave, which means you can walk away and say nothing, or you're being detained, which means the officer needs a lawful reason to keep you there, or you're under arrest, which is a whole different level of legal consequence. But when the officer says, "We got a call," they often leave that status deliberately ambiguous. And ambiguity is power, because if you don't know whether you're free to leave, you tend to stay. If you stay, you tend to talk. If you talk, you tend to give them something. This is where it turns. When you say, "I don't answer questions. Am I being detained or am I free to go?" You're not just refusing to talk. You're forcing the encounter into a legal category. You're making the officer choose. Either they articulate a reason to detain you or they let you go. And if they do detain you, now their actions are being measured against a legal standard, not just a vague call from an unknown person. Let me be honest with you. This does not always make things feel easier in the moment. In fact, sometimes it does the opposite. The officer might pause, they might look at you differently, the tone might shift slightly, you might feel tension rise. That's real. That's human. And that's exactly why most people don't do it. But the discomfort of that moment is not the same thing as legal danger. In many cases, it's the opposite. It's the moment where you stop giving away control. Now, there are exceptions, and this is important, because real life is not clean or simple. If you're driving, you generally do have to provide identification, your license, registration, insurance, depending on the state and the circumstances. That's not the same as answering investigatory questions. You can comply with lawful identification requirements and still say, I don't answer questions. Am I being detained or am I free to go? Those two things can coexist. If the officer has reasonable suspicion or probable cause, they may detain you regardless of what you say. Your words don't magically dissolve their authority, but what your words do is prevent you from strengthening their case against you. They stop you from filling in gaps that might not have been there. And here's something people don't like to hear, but you need to understand it if you want to protect yourself. Officers are trained, explicitly trained, to use conversation as a tool, not because they're bad people, not because they're out to get you personally, but because their job is to investigate, to gather information, to develop probable cause where it exists. They're trained to notice hesitation, to follow up on inconsistencies, to keep you talking just a little longer. So when they say, we got a call, it often serves two purposes. One, it justifies the contact. Two, it invites you to respond. And most people accept that invitation without realizing it's optional. Let me give you a real example that mirrors cases I've seen more times than I can count. A man is sitting in his car outside an apartment complex late at night. Someone calls it in as suspicious. Officer arrives, approaches, says, we got a call about someone sitting in this car. What's going on tonight? The man laughs it off. Oh, nothing. I'm just waiting for my cousin. He lives here. Seems harmless. But then the officer asks, which apartment? The man hesitates. I think it's 3B. Officer checks. There is no 3B. Now the tone shifts. Now the officer is curious. Why did he hesitate? Why did he get it wrong? The man senses that shift and tries to fix it. I mean, I don't come here often. Might be 2B. Now we have inconsistency. Now we have nervousness. Now we have a longer detention. Eventually, the officer asks him to step out of the vehicle. A pat-down happens. Something unrelated is found. A case begins. And when you read the report later, it doesn't say, this started from nothing. It says, subject gave inconsistent answers about his purpose and destination, appeared nervous, could not identify the resident he claimed to be visiting. That's how it gets written. That's how it gets justified. Now imagine that same encounter with one difference. We got a call about this car. What are you doing here? I don't answer questions. Am I being detained or am I free to go? The entire trajectory changes. There are no inconsistent statements. There is no expanding narrative. The officer now has to rely on what they actually have, not what you might accidentally provide. This is where people push back. They say, but won't that make me look guilty? And here's the hard truth. To some officers, yes, it might. It might make you look uncooperative. It might make them more suspicious. It might prolong the interaction slightly. That's real. That happens. But suspicion is not the same as evidence. And looking guilty is not the same as being provably guilty in a court of law. The system runs on what can be articulated, documented, and defended, not on gut feelings alone. Let me be even more direct. People don't get charged because they looked nervous. They get charged because of what was found, what was said, and what was documented. And your words are often the easiest piece of that puzzle to control. Now, let's talk about what's happening inside your body in that moment, because this part matters more than most people realize. When an officer approaches and says, we got a call, your brain doesn't process it like a neutral statement. It processes it like a threat. Adrenaline kicks in. Your heart rate goes up. Your thinking narrows. You go into what psychologists call a compliance bias, where your instinct is to reduce tension by cooperating, by explaining, by smoothing things over. And under that kind of pressure, people don't speak carefully. They speak quickly. They over-explain. They fill silence with words. They say things they didn't mean to say, or say them in ways that can be misunderstood later. That's why the phrase matters so much. I don't answer questions. Am I being detained, or am I free to go? It's not just legal, it's psychological. It gives your brain something rehearsed, something automatic, something you don't have to invent under stress. It interrupts that urge to ramble. It buys you space. Now, this is the part most people never think about until it's too late. Body language. Because even if you say the right words, how you say them matters. If you're aggressive, if you're sarcastic, if you're visibly hostile, you increase the chances of escalation. But if you're calm, steady, hands visible, voice even, you communicate something very different. You're not a threat. You're not resisting. You're simply asserting a boundary. And that distinction matters, both on the street and later, if that body cam footage is ever reviewed in court. Keep your movements slow. Don't reach suddenly. Don't step forward into the officer's space. Let the words do the work. I don't answer questions. Am I being detained or am I free to go? And then be quiet. Silence in that moment is not weakness. It's control. Now, sometimes the officer won't answer your question directly. They might deflect. They might repeat their question. Why won't you just tell me what you're doing? Or, if you have nothing to hide, why not answer? This is where most people crack because it feels like pressure, like you need to justify yourself. You don't. You repeat the phrase, I don't answer questions. Am I being detained or am I free to go? And you let that be the answer. If they detain you, you comply physically without resisting, but you continue not answering questions. If they let you go, you leave calmly. No sudden moves, no sarcastic comments, no victory speech, just leave. And if they ignore you completely and continue questioning, understand what's happening. The encounter is still unfolding, and your consistency matters. Every time you repeat the phrase, you're reinforcing the boundary. Every time you stay silent, you're preventing the situation from expanding unnecessarily. This is not about winning an argument on the street. It's about protecting your position if that encounter ever gets examined later, where words are frozen in reports and footage, and where one sentence can be replayed over and over again. Let me be clear about something else, because this is where people sometimes go too far in the other direction. Asserting your rights is not a magic shield. It doesn't guarantee you won't be detained. It doesn't guarantee you won't be searched if there's legal justification. It doesn't guarantee the officer will like you. What it does is remove one of the biggest variables you can control, your own words being used against you. And in my experience, that matters more than almost anything else, because once words are out, you don't get to take them back. You don't get to clarify them later the way you think you can. They get written down, interpreted, and sometimes misremembered in ways that are very hard to undo. So when you hear, "We got a call," I don't want you to hear it the way you used to. I don't want you to feel that automatic urge to explain. I want you to recognize it for what it often is, the opening move in a conversation that can go in very different directions depending on what you do next. And I want that one phrase to be so familiar, so practiced, that it comes out of your mouth without hesitation, even when your heart is racing. I don't answer questions. Am I being detained or am I free to go? Because in that moment, you're not being rude. You're not being difficult. You're doing something very simple and very powerful. You're choosing not to build a case against yourself. And that choice, more than anything else, is what separates people who walk away from those who don't. So don't wait until you're under pressure to figure out what to say. Say it now, out loud, a few times, until it feels natural, until it feels automatic, until it replaces that instinct to explain. Because when that moment comes, and for a lot of people it does, it won't feel like a legal lecture. It will feel fast, uncomfortable, and uncertain. And the only thing you'll have to rely on is what you've already practiced.